Hello, everybody. Chuck Cook, the very handsome Aaron Hall, the very guapo Greg Siskin. We're going to start this week. We're going to start talking about the H1B victory. Aaron, you were just reading the judge's decision. What is your takeaway from the judge's decision of a motion to dismiss?
Very clean and swift dismissing of all of the government's arguments on the motion to dismiss. It was really a satisfying read. They have that our plaintiffs have standing, the case is not moot, and that he expects it to go forward. And I think it was just this morning where he made a separate order saying it's time to file an answer. Yeah.
So I've already talked to government counsel. I'm not going to talk about the conversation here in public, but we'll talk about colleagues later. But we'll be getting some. We get, by the way, the administrative record. This is an APA case. All right, so we automatically get the administrative record, but the administrative record is basically in the Federal Register, right? Except they're going to give us all the comments. We get all the comments, the actual comments too, but we don't get necessarily any. Beyond that, any internal deliberation on this. But our focus on this regulation is very narrow. It's narrow in the context of them simply rejecting outright the issue of duplicate filings for same individual by different employers. They just basically said it's not a problem or we can take care of it. They now know it's a big problem. And, when you prevail on a motion to dismiss, that's a good sign for later in the case.
I wonder if they think there's that it's just technically too difficult for them to do it versus thinking that that we're overthinking it from a policy perspective. And they're just like, well, we don't know how to eliminate the duplicate applications.
Well, that brings up an important.
I'm just wondering what we they haven't had this conversation with us, so.
Well, it'll be interesting because on the regulatory agenda there's a notice that they're planning on tackling this, right?
Yes, in May after this year, after trying to screw another whole group of people over in this year's lottery. And by the way, I don't know if there's a fourth lottery. Right. We don't know. Some of our plaintiffs insisted that there's going to be a fourth round.
Well, we know they clearly can't figure out the correct number of people to select.
Well, because of the duplicate filings.
Right.
It's clearly a major issue. But, Greg, you're talking about them. Well, how can they figure this out? About 50 years ago, they invented this thing called the computer. And databases came along shortly thereafter. And, you can, I don't know if you know this or not, but you can actually program things to look for other.
Yeah, no, you can just if you just put the beneficiary's passport number in, that's going to be a unique identifier. And there are ways that it can be done on there. It's just they've never shown much competence in terms of being able to do technical fixes. So maybe they're getting their act together.
I recommend to the government a two sentence or even a one sentence addition to the regulation, which basically says duplicate applications, multiple applications for the same individual, different employers is hereby prohibited.
Right.
So one sentence.
Yeah, no, that's true. If somebody knows they're at risk of not only not getting, that they could, even if they get selected for just one, that they're at risk of it all crashing down on them, they're going to comply.
Well, I was just thinking about this out, in my brain. They already scanned for the same employer sending the same individual twice. So they clearly can recognize people individually with the data they currently take.
Yeah.
So why?
My question is, the State Department had this issue years ago with DV.
Yes.
And they were able, I think they've successfully dealt with the issue. By the way, Aaron's too young to remember this. Chuck and I do remember when people would be filing these things by the thousands. They would
this is our friend Bernie Wolf.
The post office would be inundated with boxes and boxes of duplicate, and it was legal.
Bernie,
that was the crazy part of it. It was perfectly legal to do that, and it was on there. That's why lawyers are basic. There were some lawyers that got into that game on there, and others are
I know our good friend Bernie would fly in from LA and walk around to the different physical mailboxes outside the Department of State with thousands of applications into boxes and like a truck, putting applications in.
Yeah. Then they went to the one per customer deal, and they seem to have, they seem to have gotten that under control.
Well, if I recall correctly, and I think I'm pretty right about this, I think the first several lotteries, they got upwards of like 50 million pieces of mail.
Yeah.
So crazy. And these were all on pieces of paper back in the day. So immigration's about 25 years behind the Department of State, which is
pretty much. But they can just pick up the phone, figure out how the Department of State did it.
So what we'll be doing on the lottery abuse case is we're going to be filing. We're going to work with the government. We obviously need discovery. There's some information we need. We've asked our plaintiffs for some stuff, but what they think we need, I was just looking at it. We're not going to ask for all of it, because we really don't need all of it. We'd like all of it, but we just need some basic stuff to prove to the judge that we're right. That in fact, this is a problem. And we'll be asking for that information. But what we'll be doing, because we need an order from the judge by February 28th. So we're going to have to make a choice about whether to file cross motions for summary judgment or preliminary injunction. Because we only have 2 months and change to get this briefed, argued, and decided without putting everybody at risk. And the reality,
we'll make a decision very soon on that.
Yeah, like quickly, and we'll let clients know. So that's it. That's where we are on the line. Congrats to our plaintiffs. Thanks for stepping up. We did, by the way, have 15 more plaintiffs who got picked in the third round. And so we're trying to figure out who you are. Would you please let us know? So we can get you dismissed. And I got that number, by the way, from the government told me. So they have the ability to track our plaintiffs. They know. I guess they could have mooted us out by just giving all of our plaintiffs.
Yes, please tell us if you were picked.
Yeah, absolutely. All right. So let's go to our next thing here. I'll go back up to the top. Oh, I did want to talk about the DVs. Obviously, everybody knows now that the government appealed the Gomez-Acker decision. With no surprise, they clearly do not want to cede authority on their visa issuance. And they must have convinced the folks in the Biden administration that their right to their do whatever they well damn please needs to trump whatever promises Biden made on the lottery, which is shocking to me. So, that suggests to me that somebody doesn't have any backbone in the White House, is what that suggests to me. Because the reality is they should have the ability to do these visas beyond the fiscal year when so ordered by a court in equity. Aaron, what are you looking at? If somebody asked me the timeline on this, what do you think?
You have some preliminary matters, and then it gets set out for briefing, and then oral argument is usually 45 days after briefing. So, we're going to be out into spring or summer before there are decisions on these appeals. I wanted to ask you, I don't understand why are they so invested in the idea that they cannot issue these visas beyond the fiscal year, even when ordered by a court? What is their thought process? What do they think they have to lose?
I don't know for sure. What I think is they don't want to do the extra work. They got a whole new crap of visa. They got 55,000 more DVs they got to do. They got to add, and they add 15,000 or 20,000 on top of that because they didn't do them last year.
Sure, but it's a weird thing to be doing this while pushing the reconciliation bill that's going to add even more than we're getting here.
It's going to add 70,000 to their. It doesn't make any sense. You're right. It makes no logical sense that they're doing this, and the only thing I can think of is power. What I always hear posited is that they just want to preserve their authority or their reading of the statute. Assuming for a second that you have kind of pro-immigrant, pro-diversity visa lottery people in power, what's the risk that this could be pushed to some negative end by a future administration? I just don't get it.
Part of me also says that they just push back on litigation now for the sake of pushing back on it, and that they don't give in until they have to give in, and that they think that they're sending some kind of message that if they push back hard on all these cases, people will stop suing.
Yeah, right. Not gonna happen.
Right, but I think that there's some of that thinking.
Yeah, could be. I think that's a good look at it.
And that it doesn't matter what the issue is. If they have to defend, they have to push back on this litigation, because if they don't, then they're sending the message to keep suing them, which they're trying to stop.
The only other thing that I can think of is that when you're a lawyer involved in litigation, you get invested in it and you start to believe that all your arguments are right and righteous, and that the lawyers who are involved might have just pushed hard to get permission to appeal because they think they were right.
Well, I think the problem is with that, it assumes that the agencies don't have a role here, and and when when we changed administrations on there, we should have seen the Department of Justice directed to make their litigation policies consistent with the policies that supposedly the administration campaigned on there. So I wouldn't just blame the Department of Justice. I'm pretty sure the agencies are playing.
Keep in mind also, they did change their position on a number of cases, just none of them in immigration.
Yeah.
They changed position on the abortion stuff, on union stuff, the judges union, for example. They changed their litigation position, just not in immigration, which suggests either that the people that deal with immigration in the White House literally have no power, or that Biden lied. I mean,
I think it's probably the former. I don't think Biden really probably even engages that much on a lot of these issues on there. But there are a couple of people, and we had this problem in the Obama administration as well, where you get senior people who who just think that they believe the conventional wisdom that immigration, that is going to use to bash them over the head politically, and they will take the toughest positions, even if they haven't really thought through and they don't have any expertise on the.
Which is shocking, because they learned no lessons from Obama. It doesn't matter how Democrats deal with immigration; they're still going to pound them over the head with it. It literally doesn't matter. So that's that case, the DV2021 our go case. There are some deadlines coming up for the government. Aaron, do we have any cross deadlines that we have to deal with?
We do. On December 30th, there's some mostly, it's basically ministerial stuff for docketing statement, certificate as to parties, a few other things. So that's January 3rd, December 30th. And then there's a deadline for dispositive motions in mid-January, of which I don't think that there will be any. And then the clerk will set a briefing schedule.
So this briefing is not that hard. These briefs are written. I mean, they're written already, right? And it's just a question of taking the stuff that judge, and keep in mind, we have the cross appeal because we think the judge's his interpretation is wrong, and his calculations are wrong. Mm-hmm. And we're going to argue that everybody should get visas. I mean, they should reserve all of them. But what I would love, Aaron, is if our case is mooted out by the Build Back Better plan. Greg, do you want to talk briefly about if you know anything more about the whole reconciliation thingy?
Unless something has happened in the last 2 or 3 hours with the parliamentarian, we are still pretty much in this holding pattern, waiting on what she has to say about it.
Does she have everything? Does she have all the provisions to analyze? I keep getting mixed messages on that. No.
She has the way the Democrats are doing this, and largely because Senator Menendez, I think, is driving this, is I don't think Senator Menendez is going to go to the mats to try and keep the backlog reduction stuff for family employment and DV folks in this bill if the legalization provisions are not, if that population is not helped by this bill, then I don't think anybody's going to be helped by this bill. So they've presented the arguments for that group. And I think that the idea is that, once they know they're taken care of, they'll take care of everybody. Or what I think will happen is if she says no on that group this time, then there will be an effort to try and bypass her, in which case everybody will be taken care of in the bypass on there, because they'll probably just use one of the versions of the House language that has been presented. But we don't know where she is at. The clock is running down. I think the Democrats know that this has to happen in this calendar year, or like within the first few days of the new year, because they do not want to be casting votes on this stuff in the election year that's coming up. So they have the parliamentarian. I think it's going to probably be today or tomorrow that she's going to issue something on there. She's already a week late from when the expectations were that she was going to release something. So we ought to know that very soon. The goal was to get a vote by Christmas. I think that is going to be difficult, and they may actually have to come back right after Christmas for this vote. And then of course we don't know yet. Senator Manchin, if it's a Tuesday, then he's against the bill, and if it's a Wednesday, he seems reasonable on there. Right now, he's like talking again, like, "Oh, I'm spooked by inflation. I'm spooked by the price tag." On there. So, when Biden's talking to the guy every day on there, and I'm sure that, Manchin's every day has another secret thing he wants to have added to his list of goodies that he's going to get for West Virginia on there, which is like, fine, that's how politics is done, whatever on there. But we don't know. That's like above our pay grade to figure out like what's happening in those conversations. On the immigration stuff, I think we're going to get some clarity very soon, or perhaps today.
By the way, Greg, I'm down to 27% is my most recent feeling.
Meter.
27%. We do have the visa fee litigation that we're doing. This is the link. To sign up.
Sign up, people. This is like an easy one to sign up for. It's basically getting money back that you're never going to get back on your own. Chuck, can I just remind people who's qualified for this case?
Yes, go right ahead.
Two different groups of plaintiffs. One group is because of the visa bans that were in place over the last 5 years, if you lost money because of one of these bans, either because you had an appointment that was canceled, or you had an appointment that was delayed so much that it was useless to you, we are suing to get your money back, and not just the visa fees, but also if you were an F1 or a J1, the CVIS fees that you paid as well. That's one group. The other group is anybody who has filed a visa application since 2016. Even if you got approved for it or not, we know that the State Department was overcharging every single person approved or denied for a visa, and we're seeking to get that. So you might be able to actually get back multiple fees if you got multiple visas over that time. And that is Chuck, I don't know if you have a link to that page that you can post, but there's no fee to join this case. We're doing it on a contingency fee basis, which means we're only going to recover if we collect money from the State Department and ICE. And that, it's being done as a class action, but we need to have a certain number of plaintiffs going forward. We're close, but not quite there yet. So we need some help from you guys. And like I said, there's a pretty sizable chunk of the immigrant population who's either in the United States or outside the United States that should qualify. So we could use your help if you want to sign up for this case. Thank you.
Awesome. We do plan on filing early next year. Is that right, Greg, if I'm not mistaken?
I think we'll file it as soon as we feel like we have the appropriate number. I mean, I think the complaint's largely drafted.
Well, come on, everybody, sign up.
Yeah.
EAD litigation. Aaron, do you want to give us an update on where we are? We're kind of within the time frame of the answer or / motion to dismiss from the government.
Sure. We haven't received either of those things yet. They had 60 days to answer, and we don't have it yet. I need to go. I don't have it right in front of me, the exact date of when this was filed. So I don't have the calculation in front of me for the 60 days. But I think the deadline should be coming up next month, right?
I think it's really early January.
Yeah.
Really early January.
So we should have some news soon.
Okay. So that's good stuff. As far as our other cases, the K1s, we're sorry, we don't have any news. Oddly enough, one of those K1s, and I think it's the Rio case, I'm not sure, one of those is Judge McFadden, who just ruled on the government's motion to dismiss in our H1B lottery case, which was filed after the motions to dismiss in the K1 cases. We are in the process of once again moving to dismiss plaintiffs that have been approved. Hopefully we'll get that done early next week. I've been a little backlogged on some stuff here at the office. And maybe that will shake this loose. What this time when we move to dismiss, we will alert the court that, we still have a large portion of our plaintiffs that are now, instead of waiting when we filed the suit a year, have been waiting a year and a half, 2 years. And, we'd like to move forward with the litigation on that. So we'll put that in there and kind of go forward. All right, guys, let's see if we have any questions here. Let's see, go up to the top. Trey is like always first. We're going to update docket info for the Go Appeal. You can go to the DC District Court of Appeals Pacer page, which has the information on the Go Appeal.
Anybody can get a Pacer account, right?
Yes, and in fact, there's some change. Aaron, did you see that change they just announced?
I'm very excited. It's going to be free.
Well, is that legislation to make it free, or is it for sure happening?
Well, it passed the House, and there's a bunch of co-sponsors from both sides in the Senate. So I think it's
that's awesome.
I think it's going to happen.
Yeah, which is going to hurt the courts because they get revenue from that to run the courts. I'm surprised nobody sued them over that. Honestly, charging you to give access to the courts. So you go to the DC Court of Appeals. You can track the Go case there. Again, I'm thinking sometime in late 2022 for a decision, Aaron. And yes, we do not know when the government will begin.
Or we get the legislation.
Yes.
If the Build Back Better bill passes, then our cases will be mooted out because those visas will be all added back to the pile. So
this is when I always come back and say maybe. We'll look at the legislation that actually passes the language of the legislation and then compare it to the order. The only thing that I would say is not only did the judge find that they should have issued more visas, but that the applicants had been unreasonably delayed. And so that they're now on a deadline of the end of this fiscal year. And if that's sooner than they would otherwise be processed from the Build Back Better Act, then it may not be moot.
The way I understand this bill, reading it, the way it would operate is there was a 6-month implementation. So essentially what would happen is all of the lotteries that are affected by the bill, which I think is the last 4 years, would essentially all reopen simultaneously in June or July, and they would be continuing on each lottery on its own track, which I know would make the State Department go bananas, but that's essentially how I think it reads, because they don't distinguish saying they do it in order or anything like that. They may get away with that in rulemaking or however they're going to do it, but essentially that's the way it would work, is that it would pick up on September 30th, whatever year it was, and act as if September 30th was no longer a deadline and just continue on processing each group the way that they would have if that deadline wasn't there.
Which they appear to be wholly incapable of doing.
Yeah.
Or unwilling to do, one of the two.
Yeah. So it doesn't guarantee you're going to get anything done quickly, but it would at least solve the issue of numbers.
Mary brings up the other big change is, hey, all those documents that we jerked you around about and made you documentarily qualified. Yeah, we don't need this. Which we've been saying all along, because we know they didn't need them, because in September of 2020, nobody was documentary. They just you walked in with your documents. Boo, man, we took care of you.
I mean, it's better late than never. I'm glad that they're making the policy change, but it just hurts to know how much heartache has been caused people waiting to become documentarily qualified, not getting responses from the few people working at KCC. And, they could have done this so long ago.
Well, at this point, it's all electronic, right? You submit your DS-260. It's this. What is it? What does it require a body to look at a form? No, I mean, this could be electronicized. You got a computer. Okay, boom, boom, boom. It's all correct. Thank you very much. Automatic check sent out. Schedule.
But to answer Mary's question, I believe that the policy, they're framing it as a pilot program for DV2022. I do not think it's going to apply for DV2021. I believe that you're going to have to get documentarily qualified, whether it's through a reserved visa or through visas through the reconciliation bill, although they could always change that.
So there you go. Oh, I did forget to mention, Greg and Aaron, about our DV 2022 potential litigation. We're in a conundrum here. We don't have the November. We don't have the November numbers yet. They haven't sent those out yet, have they? And our friends at the State Department I'm going to check really quick right here. Go online to their website. I don't think they've put the November numbers out because I'm sure we would have heard about them already from folks. No November numbers. We don't know how many they didn't issue in November. But near as we can tell, basically nobody.
Working on them.
And those 12 that they issued in October, they appear to be for 3 different families in 3 different countries. And I'm not sure, honestly, that they were DV 2022s. Not convinced that they were.
Yeah, I mean, honestly, this is not something that they could sort of not. I mean, this has to be a specific policy that we're not aware of that's actually directing them not to work on these cases because it's, they could be slow about it and a trickle getting through. But this is like basically broadcasting that they are telling them not to work on these cases. Yeah, so we have started. We're working on apps for a new for a new case, and that we'll just decide when we're going to actually release that and start onboarding. But I'm pretty sure unless there's some dramatic change that we're going to see in the new numbers, that's going to be a case that we're going to be working on.
So what we'll do is we'll let everybody know next week with a login, hopefully the login. It's still not Christmas next Monday, right? Today is the 14th. So we'll talk to everybody about the DB22 litigation. But this is clearly a breach, I think, of the APA because they're clearly instituting an unwritten policy to not adjudicate these cases. How could they be the only case they're not adjudicating? Now, I can see their defense. No, they're not. We're also not adjudicating EBs either. No employment-based visas either. But the reality is, even though they technically got rid of their prioritization schedule, it's clearly still being used.
They seem to be working on some of the EB immigrant visa cases, though. According to at least Charlie Oppenheim was mentioning that that was one of the reasons why he was more optimistic that we weren't going to be in a Chakrabarty situation this year, that they were going to actually get through the numbers. Now, I don't know yet. I don't think we've seen actually numbers to confirm this, but he was saying that USCIS's adjudication pace had improved, and they were also seeing more numbers coming from consular processing of employment-based immigrant visa numbers.
Yeah, but Charlie was Charlie who? Is he retired?
The former Charlie.
But he was basing that on the improvement in August, September, and October by USCIS, which they said they could not sustain because they took people from other product lines, i.e., employment-based applications, family-based applications, to do adjustments.
Right. So but I'm only mentioning it because he mentioned in that comment that the situation had been improving for employment-based numbers.
Yeah. Well, I think that improved
for consular-based employment cases.
Well, if consulate, we'll see. But again, if they're not interviewing anybody anywhere in the world, what the hell's going on?
Yeah.
All right. Jason Claus. Jason, how are you? Any official emails admitting anything wrong? No. I don't know what you're referring to, admitting any wrong. No, the government's not admitting anything. Any case of the AAD lawsuit? We talked about that a little earlier. Any thoughts when the 765 adjustments? Oh, this is the premium processing. Now, Greg, you made a good point about this. I think earlier, I think it was you earlier today. All they're doing is proposing the rule. They're not saying they're going to do it.
No, but I mean, first of all, I think there was a lot of question marks regarding whether they need to even do a rule. Congress gave them, legislation that pretty much was pretty direct in what they can be doing on there. So I don't know why they would need to do the rule in the first place, to comment on why Congress ordered them to do this and they can do it on there. But nevertheless, they did tell us months ago that they felt like they had to do rulemaking, and we had been waiting for this moment. I think that the plan is to, I don't think this is for show. I think they do actually want to proceed with premium processing. Yeah. What I think the concern has been is that they can't deliver on it. And it's a chicken and egg problem. They're going to get flooded with cash, which should allow them to hire a lot more people. But at the same time, you have to deliver on it now if people are paying for it. So my guess is it will be, they're just going to have to be smart about how they roll it out so that they, it's not going to all happen at once. We were told 765s and 539s would be the first products that they would put it on. They told us that last summer during the AILA conference that those were the priorities. So this is not just something they woke up last week and thought about. They've been thinking about it for a while. And, with the Kang case and with some of the others that are out there right now, that is this could solve that problem for them if they can get their act together on this and start adjudicating.
This is a great scam, by the way. You create the demand and the need to premium process by not adjudicating cases in a reasonable period of time, and then you charge an outrageous fee to do the job that they refuse to do for the outrageous fee you already paid.
Yeah.
Man, it's
if you think about it, for 12 minutes of work, how much is it going to cost with $1,500 plus? What is it?
What's the 10? It's almost $2,000.
So we're talking about $1,900 for 12 minutes. That's
$1,500
of an hour.
$12,000
So that is 1,200. What is that? $1,800.
Between $11,000 and
times 5. Oh, so it's about $9,000 an hour.
Not bad money if you're in the money game.
Yeah.
But I think why they want to do those first is because it doesn't take any training to do those.
Mm-hmm.
If you're going to do premium processing on EB1 multinational manager executives, you don't just haul somebody off the street with a high school diploma and teach them how to look for that. Then the idea is say, these are the name category, these are the codes.
Yeah, I agree. They clearly, for that category, they clearly have the ability to deliver on it with that. And what would happen is that the $1,500, those would go to the front of the line, and they would just move it only takes 12 minutes, so they can shift the workload around and collect the money. That should be a relatively easy decision for them on the 765s. It gets more complicated in other categories, but I totally agree with you, Chuck, that makes sense to start with that one.
Yes, and then bring in enough money to do everything else. But amazing how they create their own demand. I think that's awesome. Congratulations. Brilliant capitalist thinking there.
Well, for something that is totally unnecessary, is from whether they're allowed to require an EAD from a policy perspective. I don't know why Congress hasn't killed this a long time ago.
Why it's not an automatic computer action is actually a better question.
Yeah.
It should literally be automatic. We talked about the visa. We don't know when they're going to issue them. We have no idea. They literally aren't talking anything about that.
Well, the only thing I'll mention on that is some of this is going to depend on Judge Mehta, and just because they've appealed this case doesn't mean that they're not on the hook to do what the judge ordered them to do in the meantime, the district court judge. So Judge Mehta is going to have to make a decision on how he's going to treat that order in the meantime.
Remember what they said at oral argument, Judge, we can't do these in 2022. That's why we need till 2023. So basically they're saying, okay, you gave us to the end of the year, so we'll take the end of the year. It would not shock me if everybody gets interviewed in August and September. Would not shock me. Let's see, Lukasz Tangi, been in the DOR such as buying technical arguments to show. I don't know what the DOR means.
They're defending the system.
I don't know. Sorry, I don't know what that means. Premium processing for H4 EADs or any EAD? I think it's for every EAD. Is that right?
It will be for every category of EAD. They didn't distinguish in the legislation, although they could, I think they have the authority at USCIS to roll it out on whatever pace they want to. So they could just decide at the beginning that it's going to be one subset of it, or whatever subset they decide.
Well, the thing with H4s is those are discretionary EADs, so they likely take longer than 12 minutes, or
Right. So they are. That's it's important that the 539s are also one of the categories that they're talking about doing quickly, and I think they were talking about doing that also at the same time with the H4 EADs in mind.
Yeah, except you have to pay the premium processing for that too.
Well, that's right on there. So, for them, it's like that would be $4,000 essentially that they would be getting for giving you an H4 EAD that quickly. And
maybe for 2.5 years, 2 years, 1 year, 6 months, who knows?
yeah, so there's, it's quite a bit of money to be made for the agency if they can figure that out.
I like this question, Aaron. What's the penalty if they don't start issuing visas?
Can they send Tony Blinken to jail? Contempt. I mean, that's the penalty on there. Is in theory, you can hold government officials accountable.
Listen, they're going to issue the visas. If there's no, if they don't win on appeal or get a stay, they're going to issue the visas by the deadline. Can we force them to do it earlier in the year? No, we can't.
In the Go case, write to the end. No, do not write to anybody in the Go case. There's nobody to write to. You just sit back and wait. Unfortunately, sit back and wait. 29 Super C says, happy holidays. Thank you very much.
You as well.
They are penalized by public shaming. There's a phrase in Spanish. I don't know if other languages have this, because English doesn't really have this phrase, but it's sin vergüenza. Now, Aaron, when I say sin vergüenza, you know exactly what that means, right? Without shame. But it's more than that. It's like completely and utterly, they don't care what you think. Sin vergüenza.
It can be a noun too. I like that. It can be a noun.
They're sin vergüenza.
Es un sin vergüenza.
Sin vergüenza. I like that. All right. We already, Lucas, we already catch up on the H1B case. HSC is for the lottery 3 months later. Well, that's what Chris, that is the goal. That's what our meta is. Oh, you get that? It's our meta, which is Spanish for goal, without the H, by the way. Got Spanish in my brain all of a sudden. So our goal is to get a final decision by the 28th. Now, we know a lot of employers and lawyers, they're getting the applicant, they're getting everything ready to go. But since it takes, I don't know, Greg, how long it takes to fill out one of those forms, I bet it's not 12 minutes. It's probably like 2 minutes. So it's no big deal. And saying at the last minute, hey, we're going to change how we do this. Yeah. Or we're simply going to add one more category. And the reality, they don't have to have the lottery on March 1. They could have it March 20th. They could just say, you know what, I know you can file in April, but we're not going to take applications until June. I mean, it doesn't matter, right? They can do it later. So obviously we know what they planned in the past, and we do want to try to meet that deadline, but we don't feel that it's necessarily the most important thing, as long as we stop the lottery from happening. Let's see. Sarah, gentlemen, real heroes, for international immigrants. Oh, thank you very much, Sarah. We appreciate it. And our last question here today: can they change their treatment based on a settlement? Yes, and we will ask them to settle the case. I'm not going to hold my breath on that one.
We're always happy to talk to the government.
Happy to do it. Happy to see what they say. Keep in mind, we never talk to the government. We talk to their lawyers.
Right. So they're right. That's true. Although they are the government too.
They're the government. Now I think we're going to also reach out to some other groups that are interested in this litigation to perhaps file an amicus brief on this. We'll see if we can get anybody else to do that with the court, but that would be very good. And Like Nanat, go back to the Go banner and you will see it right there. We already talked about that. All right, guys, it's been great to be with you all this week. You guys are staying on board while we talk afterwards, but we will see you next Monday. And the following, are you guys open the Monday after Christmas?
I am going on vacation from the 19th to the 26th. So it won't be me, but it could be potentially somebody from my office.
Same here.
Okay. And I will likely be here. We are taking Christmas Friday off this year, Christmas Eve. We don't have a Monday holiday this year. Although, like everybody else, we're monumentally short-staffed during that week. So, all right, guys, we'll see you next week.
Well.